Good morning. Welcome and thank you for attending today's FASD Learning Series webinar. Our theme for this year is prevention. We opened the season this fall with a presentation by Nancy Poole, who challenged us to think about what we know about prevention and whether we're actually doing it. Today, Dr. Vinesh Gupta will discuss the concept of FASD and criminal responsibility in our legal system. Before I introduce Dr. Gupta, we've got a few housekeeping items. You can ask questions during the presentation by using the question and answer module on the right-hand side of your screen. Session facilitator is monitoring the questions and will pose them at suitable times during the presentation. If we're not able to answer all of the questions during the live presentation, we'll answer them via email after the session is over. It's important that you include your email address when you ask a question, otherwise we won't have any way to respond to you. The presenter's contact information is included at the end of the slides. In order to receive your certificate of attendance, you have to have signed in after 8:50 a.m. Evaluations for the session will be emailed to you after the session is over. Please do fill them out and return them, as we rely on your feedback to improve what we're doing and how we're doing it. Today's presentation and handouts are posted for viewing on the website about 2 weeks after the presentation is complete, and that's at fasd.alberta.ca. If you experience any technical difficulties, please email support@cmgcanada.ca. That's support@cmgcanada.ca. And please also let your local tech support know, as the problem may originate on your end. As Alberta advances with the FASD 10-year strategic plan, education and training continue to play a key role. This is our 5th year of offering the sessions and our 2nd year of delivering the materials as webinars. As always, all sessions are taped and made available on the CMC website, fasd.alberta.ca. We're pleased with the ongoing interest and attendance in this initiative. We appreciate the work of CASA, Child, Adolescent and Family Mental Health, and the Alberta Centre for Child, Family and Community Research in making this initiative a success. Now please join me in welcoming Dr. Gupta.
Thank you. Morning, everyone. First of all, I should say, actually, I didn't include my email address at the end of the slides, but I will say that, hopefully try and remember to say that when I'm done. So I was contacted by Jean Anderson from CASA about 6 months ago to do this presentation. I have done a couple of presentations for the FASD network in the past as well. And we were kind of scratching our heads thinking, what should I talk about? And my main area of work is with young offenders. And to just explain that, I work with youth from ages 12 till 21 who have been involved with the criminal justice system. So they have been charged with an offense and then end up being through the criminal justice system. So on occasions, the courts might decide to ask for an assessment, or when they are within a young offender center, they might become unwell, in which case the staff from Young Offender Center would contact the unit to see if we can admit them. So my base is Alberta Hospital Edmonton. I'm part of the forensic services there, and we get youth who are, as I said, involved with the criminal justice system. Some of them come in while they are still on remand, which means that though they have been charged, but they haven't been found guilty yet, or they haven't been sentenced. While some others might come to us once they have been sentenced and they become unwell while they are serving a sentence. On occasions, we accept youth for treatment as well, which is sometimes part of the assessments that we do while they are on remand and make recommendations for them to come to the hospital for treatment. There are a few kinds of remand assessments that we do. Just to give a brief background for people who are not very familiar with the Youth Criminal Justice Act. So the assessments for young offenders can be ordered under Section 34 of the Youth Criminal Justice Act. What that essentially is, briefly, that if the court, and when I say that, that means either the defense, the Crown, or the judge can raise some concerns or have concerns regarding the youth, whether they have a mental illness or not. They can order a psychiatric assessment or a psychological assessment under Section 34 of the Youth Criminal Justice Act. Sometimes they can order assessments for fitness, sometimes for criminal responsibility, and we'll be talking about the concept of fitness and criminal responsibility. And as of 2003, under the Youth Criminal Justice Act, another category for assessment was added, which is called intensive rehabilitative custody, supervision, and sentence, which is only available for youth who have committed a serious offense like murder, manslaughter, violent sexual offense, or a serious violent offense. So that's basically what we do at the unit where I'm based. So, and we do get a number of youth who have symptoms or features suggestive of fetal alcohol spectrum diagnosis. And that's when Jean contacted me at that time. We had a couple of youth who were going through the system. One of them had been found not criminally responsible at that time, and there was another one where we were dealing with fitness issues. So that's when I thought maybe that might be a good thing to talk about. So initially it was supposed to be only about not criminally responsible, but then as I was going through the case laws, the material, the cases that we have dealt with, I thought it probably would be appropriate to talk about fitness as well. So even though I started by saying that we'll talk about FASD and NCR, I am going to talk about some issues around fitness to stand trial, as well as some sentencing considerations when there is a youth or an adult who have been diagnosed with FASD. And as just mentioned earlier, please feel free to fire any questions that you may have, and I'll try and address them as we are going through the presentation. So the objectives of today's session is understanding the concept of unfit to stand trial. We had a 13-year-old youth on the unit not long ago who wasn't FASD, but definitely had some limited cognitive abilities, to the extent that following the assessment, we felt that he probably may not be fit. He'd been referred to us for a Section 34 assessment. So I wrote a letter to the court suggesting maybe we should look at a fitness assessment. So the court addressed the issue of fitness, and subsequently his lawyer ended up calling him to suggest that he's likely to be found unfit. Now, we were not aware on the unit that he's had this conversation with his lawyer. And after the phone call, the youth became very upset. And he actually ended up damaging quite a few things in his room. So I was asked to talk to him. I went in and he goes, "I'm very unhappy." And I said, "What happened?" "My lawyer told me I'm unfit. That means she's talking about my weight and I'll have to do these exercises and talk about my diet. I'm not happy about it." So on the one hand, it was funny, obviously, but on the other hand, it explains that this guy had no clue what we were talking about. He had no idea what fitness is. He had no idea about the court process. And he's charged with a few offenses. So that's where it becomes important to be aware of some of these things and deal with them properly. So that's one of the objectives, obviously. Then we'll look at, so hopefully by the time I finish, people won't be getting upset when I tell them that they're unfit. So it's a different criteria when we talk about that. Then it's about relevance of being unfit to stand trial to FASD. I'll also briefly talk about the concept of NCR, or being not criminally responsible, and then obviously its applicability to FASD, and then specific considerations that sometimes courts have when they are sentencing people with FASD. So that's what we'll talk about. So just to give a brief overview of FASD, a quick overview. FASD was first used by Jones and Smith in 1973 to describe a group of children who were born to alcoholic mothers with growth retardation, had very characteristic facial features, had central nervous system involvement, and there were issues around development, emotional, behavioral, and social deficits. The concept has evolved significantly since then. And I think FASD, as far as central nervous system deficits are concerned, or brain injury deficits are concerned, in mental health is probably one of the most researched diagnoses or most researched deficit. So there are several classifications of FASD. I'll just talk about one quickly. So to have FASD does not necessarily mean that a person fulfills all the criteria or has all the symptoms that are associated with fetal alcohol spectrum. So the concept of FASD itself has been divided into 4 categories, where fetal alcohol effects means that a person presents with all the symptoms or all the features of prenatal alcohol exposure. What it also means is that there is a confirmation of prenatal alcohol exposure. There are the typical facial features and the cognitive deficits associated with it. While partial FAS could be where there isn't a confirmation of prenatal exposure to alcohol, or alcohol-related birth defects, or ARND, have similar issues where there may or may not be confirmation of prenatal alcohol exposure. There may or may not be the typical cognitive deficit profile, or there may or may not be all the facial features that are associated with FASD. So what is important to understand is that having a diagnosis of FASD does not necessarily mean or imply that that particular individual has all the typical features of FASD. They still could have an average IQ. They may not have the typical facial features. And usually, as an individual with FASD grows older, the facial features tend to subside. They're not as prominent as they might be in a young person. So there are obviously multi-system deficits associated with FASD. So it affects the cardiovascular system, the skeletal system, renal, ocular, auditory, and central nervous system. So our main focus is obviously the CNS abnormalities. Usually, when somebody has had prenatal exposure to alcohol, they present with decreased cranial size, so that their head is small. They might have cerebellar hypoplasia, so their cerebellum is not well developed. They may have neurological hard or soft signs. So what that means is they may have difficulty performing certain activities. So they may have impaired fine motor skills. Which could manifest as having difficulty in tying shoelaces. They may not learn to bike till a later age. They may have neurosensory hearing loss, poor tandem gait. So usually they present with kind of awkward gait. They may not be able to walk on a straight line, and poor hand-eye coordination. So one of the things we see is they have difficulties with very fine activities. So sometimes things that do manifest in school could be their handwriting is not very good. So they have difficulties with handwriting skills. So those are the kind of things that might be seen with CNS abnormalities. So how does it manifest as far as cognitive deficits is concerned? So they present with learning difficulties. Again, going back to the point that not everyone who has had prenatal exposure to alcohol has a low IQ. So they may not necessarily present with learning difficulties. It could be a feature, but not necessarily present in everyone diagnosed with FASD. Obviously, if they have learning difficulties, though, they are likely to have deficits in school performance. These are usually the kids who end up being identified as disruptive in classroom. They end up attracting several diagnoses like ADHD, like conduct disorder, oppositional defiant disorder, behavioral control disorder, all sorts of stuff. Because they also have impulsivity. They do not necessarily stop to think before they act. They also have significant memory difficulties. So they can't necessarily remember stuff that is being taught at school. We had a 17-year-old youth on our unit who had some learning difficulties, was diagnosed with FASD, and the teachers struggled quite significantly trying to ensure that he was able to retain what was taught to him. So the same things had to be repeated over and over and over again. And despite that, retaining theoretical concepts was not easy for him, which is made further difficult by difficulties with attention and concentration. So though they do not necessarily warrant a diagnosis of ADHD, but they definitely have features which could lead to a diagnosis of ADHD. So they have difficulties with attention, concentration, impulsivity. So, and coupled with low cognitive deficits, low cognitive abilities, memory difficulties, they don't do very well in school. They usually end up spending a lot of time being suspended or sometimes being expelled from school. Impaired judgment. They don't necessarily think about the consequences before acting on something. They don't think about, oh, if somebody's telling me to go and punch somebody, am I going to get in trouble for doing that? Maybe, maybe not. Doesn't really matter if I am. I'll still do it. I might end up making 4 friends if I do it. So that's the way they think. Usually they're isolated. They want to be part of something. They want to be part of a group of friends. So they have very short-term judgment issues there. So they think about the short-term gains from their actions. They are not necessarily able to understand about the long-term aspects of their actions. And they don't necessarily have good daily living skills. They don't have good budgeting skills. Again, going back to the 17-year-old, we had significant trouble trying to make him understand the value of money, the value of budgeting. He just wanted the labeled clothes. He wanted the big label shoes because that is what everyone wants. Doesn't really matter if I won't have money to buy my grocery out next week. Who cares? So those are the kind of living skills that they lack, and they fail to learn from their mistakes from past. There are, as I said, issues around memory, attention. They also have difficulties with language. They can't necessarily communicate very well. Sometimes they might present as being able to understand what is being said to them, but they may not necessarily actually comprehend the information that is being given to them. Or even if they are able to comprehend, they may not be able to communicate it back. So they might present as people who are able to understand whatever is being said to them, whatever is happening around them. And that is especially relevant when we talk about scenarios in a court, in the criminal justice system, the kind of language that is used in criminal justice system. So a 15-year-old or a 16-year-old youth might present as to a police officer on the street that, yes, I understand the caution being given to me. Yes, I understand my rights. But they may not have actually understood anything that has been said to them. So to give you an example, in the forensic services where I work, we have some limitations around confidentiality. And those limitations are because of the system we work in. So when a patient is admitted to the unit, they're all advised that the information that they share with us is not confidential. And that is because they are there for a court-ordered assessment. So the court has the right to access that information. And a number of times, these youth would indicate, yes, they understand it. So over the years, I have changed my practice from reading the statement out to them, actually giving the piece of paper to them with the statement written down on it, asking them to read it, and then relay it back to me as to what their understanding is, not just reading it back to me. So it was only yesterday, I gave it to one of the youth. He read it and he straight away goes, yeah, I understand you will keep everything confidential except if there are concerns about me harming somebody or harming myself. And I'm sitting there and thinking, there's no mention of harming somebody or anybody, yourself at all in this statement. And the youth actually hadn't even read the statement. It was more than obvious, because if you go to a general child psychiatry clinic, that's what happens. The therapist, the psychiatrist that you're talking to, if you're a 13, 14, 15-year-old, will tell you, look, we will keep everything confidential. Unless if we are worried about the risk that you might pose to yourself or others. So what he had done is, he somehow had that in his head. So he thought it's probably the same thing. I don't need to read the statement. Why bother to read the statement? And he skimmed through it and said, this is what it is. So, and this is a very simply worded statement which is only 3 lines. Now imagine this youth who is 15 years old being in a situation where he's on the street, being arrested by the police and being cautioned. What is his level of comprehension? Is he actually listening to what is being said? If anything, his ability to comprehend has gone down significantly, because he's probably anxious. He's probably thinking about, oh, can I run away from here? Can I escape this guy now? Or am I going to be in jail? So try and make him understand that statement at that stage. How difficult will that be? So that's where we'll talk about some of those things more when we talk about fitness issues. And they have obviously ongoing executive control difficulties as well, so they can't plan, they cannot organize themselves. They don't necessarily learn from past mistakes. They don't necessarily link cause and effect. They don't anticipate consequences. So if I punch somebody at school, yeah, I'll make friends. But what they don't think about is, I could potentially get suspended or I could be expelled. So they don't necessarily think about it. And they have difficulty taking the perspective of others. So that's where sometimes we talk about, oh, so-and-so doesn't have remorse. They don't have empathy. But that's because of FASD. And we need to understand that it is different from somebody who might be labeled as a psychopath or who might have antisocial personality disorder, where they lack the ability to experience remorse or empathy. So FASD people, an individual with FASD, when they have difficulty taking perspective of others, putting themselves in somebody else's shoes, it's not because that is their personality trait. It is because they have a brain damage which results in them having difficulty experiencing those. So that is very important to understand. So however, if you sit down and talk to them once they've done something wrong and try and make them understand, they would express guilt. They would feel, yeah, it's what I did was wrong. But at the same time, they might repeat the same thing again in half an hour, in a day, in 2 days, because they don't necessarily remember that. They don't understand the consequences. So concept of fitness, it's a legal concept, and what it implies is that an individual is unable to understand few things within the court, whether that is about the process or whether that is about the consequences on account of mental disorder, to conduct a defense because of an inability to understand the nature or object of the proceedings. So as a 13-year-old, if I'm in court, there are all these people who are in these fancy robes. I don't know what are they talking about. I have no clue that they're talking about me. I don't know what are the charges against me. So not being able to understand what is going on or understand the possible consequences of the proceedings. So if I plead guilty, what happens then? If I plead not guilty, what happens as a result of that? or being able to tell my lawyer, communicate with the counsel, this is what I want. I want you to plead not guilty on my behalf because I did not do this. Or I want you to plead guilty for 2 out of the 3 charges because the third one is serious one, and if I plead guilty to that, I could be in trouble. So I want a shorter sentence. I want to be able to go home as soon as possible, or I don't want a custodial sentence. So a lot of people with FASD do not have that understanding. They don't understand the legal jargon that is used in the courtroom. Even we who are supposedly with normal intellectual ability, our normal people have difficulty understanding some of the legal jargon if we go to the court. I go to court probably once every 2 months, 3 months, and I still have problems understanding some of those things. So imagine a 13 or a 14-year-old who's probably functioning at the age of 6 or 7, going through the court process and then being expected to understand all that, which is further complicated by possibly them being anxious, being worried about what is going on, what's happening in court. So there have been a number of cases in court which have dealt with issues around fitness. And one of the big concepts is a limited cognitive versus analytical capacity. And I'll come back to that because I want to talk more about fitness first. So when we assess an individual to see whether they are fit or not, we talk about few things. We need to know whether they know certain things about the charges, whether they know what are they charged with. So, and they don't necessarily need to know the legal language when it comes to the charges. Yeah, I was charged with assaulting somebody. I was charged with hitting somebody. So they don't need to know whether it's an assault or an aggravated assault. So that becomes more of a legal language. As long as they understand that an aggravated assault or an assault means that they had hit somebody, they assaulted somebody, that's fine. Or I was charged with breaking into a house. So they don't need to know it's called break and enter. Or uttering threats to cause death or bodily harm. So as long as they know, yes, I threatened somebody, it's fine. Do you know the difference between pleading guilty and not guilty? So do they know what does guilty mean? Do they know what does not guilty mean? What happens if you were found guilty? What happens if you're found not guilty? What is the meaning of an oath? So do they know that when they put their hand on the Bible on a witness, on a stand and say they are going to tell the truth? That is what is an oath. A number of those people, they don't know what is an oath. Half of them actually don't even know whether they have a lawyer or not. Or if they know they have a lawyer, they don't know what's the name of the lawyer. They don't know how to contact their lawyer. Do you trust your lawyer? If you have a lawyer who's from legal aid, every time you go to court, it is likely that your lawyer changes. And they're expected to trust their lawyer. So I walk in, see a new person every time who doesn't even talk to me, and something happens in court which I have no idea what happened, but there was a lawyer and they said I have to come back in 20 days. Do you know why? What did they talk about? No, they just told me I have to go back to the hospital and that's it. So there's absolutely no understanding as to what happened. So, and I'm aware that the criminal justice system is trying to deal with some of those things, and my understanding is if I talk about the law courts in Edmonton, they're actually trying to implement a system where one lawyer from Youth Criminal Defense Office gets allocated to one youth. So irrespective of how many times they go back, it will be the same lawyer who will be working with that youth. And if I'm not wrong, and I could be wrong on this one, the same system is trying to be implemented by the Crown prosecutors as well. So it's one Crown prosecutor who will have the file. But this is, I'm only talking about youth in general. I'm not talking about youth with FASD. I'm not talking about adults with FASD. But it's a good start. So this is something that we need to build on. The next thing they need to know is, what do they want their lawyer to do for them? As I was saying, do you want me to plead guilty for all the charges? Do you want me to plead not guilty? Do you want me to plead guilty for some of the charges so that I can get a lesser sentence? So if I don't know my charges, how do I talk about this stuff? I don't know. I've got 7 breaches. I was only arrested once because I was out of the house late. I had a curfew till 10 o'clock, but I was out till 11. But I suddenly have 7 charges. I don't know what are those. So what is important to understand is, if someone is arrested, for example, a situation, a 16-year-old youth who has some conditions attached to their sentence, and those conditions are to stay at a residence, specified residence, follow a curfew, which is from 10 p.m. till 7 a.m. in the morning, not use alcohol and drugs, keep the peace and be of good behavior. If they're outside after 11 o'clock or 10 o'clock, always be accompanied by an adult. Now for them, when they get arrested at 11 o'clock by the roadside, all they're looking at is, oh, I was supposed to be at home and I wasn't home. But they have broken all the 5 conditions probably. They're not at the specified residence. They were probably arguing with somebody. That is why they came into the attention of police. They probably had a few drinks. They were not accompanied by an adult, and they were outside after their curfew time. 5 charges right away. And that's what they don't understand. So they would have no clue that that one arrest resulted in 5 charges. And it's not uncommon for us to have, and I keep on talking about youth because that is the population I work with. It is not uncommon for these youth to come into the hospital saying, yeah, I think I have got 2 charges. And then you show them the list of the charges, and they're usually very surprised because they would have no clue as to what happened there. Try to ask them, who are the people in court? A large number of these youth have no idea. So we are simply talking about the judge, the Crown prosecutor, and a defense lawyer, and that's it. We don't even expect them to know that there is jury, we don't expect them to know there is court reporters, we don't expect them to know anything else. We only need them to know whether they know there is a judge, whether they know there is a Crown prosecutor, and whether they know there is a defense lawyer. What are the roles of these people? All that is expected is the defense lawyer is on my side and is trying to help me. Crown prosecutor is against me, trying to get me a longer sentence. And judge makes a decision based on the evidence presented in court, makes a verdict, and gives me a sentence. And that's about it. And believe me, we get a large number of youth who have no clue about these things. Absolutely none at all. But then we have to think about a 15-year-old average youth with normal intelligence. How many of those know about these things? They've never been to the court. They don't know what a Crown prosecutor is unless they have specifically read about it in their school and in the curriculum. Who knows what does the judge do? Who knows what's a verdict? Yeah, judge makes a sentence and that's about it. They don't know what does a Crown prosecutor do. They don't know what to ask their defense lawyer. And these are then people who have significantly lower cognitive abilities. They don't know what are necessarily the sentencing options available to them. What's a plea bargain? I'm not sure how many people know what's a plea bargain. So if I am charged with stealing a bicycle, stealing a car, if I plead guilty to just stealing the bicycle, and the Crown agrees to drop the charges of stealing the car, which is likely to be much more expensive, then I'm likely to get a shorter sentence. So that's a plea bargain. So I'm negotiating that I'll plead guilty to a lesser charge if you agree to drop the more serious charge, so that way I can get a lesser sentence. That's quite a complex thing to understand. Lots of these kids have no idea about those things. So as I said, people with FASD could present with higher communication abilities than what they usually have. They might affirm, they might say that they understand their right to silence, the right to counsel. So when anyone is arrested by police, they have a right to keep silent. They do not have to say anything to the police. So what we see in the movies is not very off from what actually happens. So when they get arrested, the police does tell them that they have a right to silence. The police does tell them that they have the right to counsel. But they may not understand the legal language or the consequences of not using their rights. And that is where the trouble comes in. Lots of these kids would actually still end up talking to the police at that time, despite the fact that they're told, look, you have the right to stay silent, or you have the right to have a lawyer before you talk to the police, or you have the right to have an adult present with you before being interviewed. Because they may not want an adult. They don't want a family member being there when they're in trouble. They don't want a lawyer because half of them don't even understand what a counsel is. They have no clue what a counsel is. Or how does it matter? The police has arrested me now. I'm outside the house. If I tell them, yeah, I'm outside the house, is it really going to matter in future? No, it doesn't really matter. So they don't understand those things. So now I would like to go back to this bit where I was talking about limited cognitive versus analytical capacity. So it is important to understand this concept. So there was a case in 1992 in Ontario court, and if people want to go and look for it, you'll have to, I think, Google search, and I can't give you the exact way of doing it, but it is R versus Taylor, Ontario Court, 1992, which was then, the decision was then affirmed by the Supreme Court in a case R versus Whittle, that's WHITTLE, in 1994. And the court addressed the issue of operating mind theory, where basically the court said that the operating mind theory does not imply that the individual being arrested needs to have a higher degree of awareness than knowledge of what is happening at that time. So all they need to know is, yes, I'm being interviewed by police, and yes, the police can use the things that I say against me, and that's it. Nothing more than that, which causes a problem. Because then what could be the consequences of that? What does it mean, use against me? Does that mean I could go to jail? Does that mean I could be found guilty of something? Does that mean I could get a longer sentence? I don't think I need to talk about this because I can keep silent. I don't think I should be saying anything without a lawyer. So the ruling was that none of that is relevant in some ways. As long as they understand that, yes, I'm being interviewed by the police, and yes, whatever I say, the police can use against me. That's about it. So with people with FASD or with youth, that causes a significant problem because they are not thinking of the long-term consequences of that. So which becomes a huge issue then when we are talking about fitness. So essentially, even a 6-year-old knows that, for example, if they're in school and they've done something wrong and the teacher is telling them off, they know if they tell the teacher what they've done is wrong, there could be consequence, and that's about it. So that's the level of cognitive ability we are talking about is expected when somebody is arrested. So having said that, I'll jump the slide again and come back to this one. There was another decision from court in 2008. Now, LTH is actually a youth who was arrested, and he had learning disabilities. So when he was arrested, police obviously called the mom, and mom informed the police that he has learning disabilities. And she also later, when she testified in court, she said that he had significant difficulty understanding most of the questions, and he would generally refer to mom for clarification. So he had a videotaped interview with the police. He had earlier waived his right to counsel or an adult being present, and the police and the Crown prosecutor submitted that videotaped interview as evidence of him pleading, basically saying that yes, he had committed the act. But in this case, the judge dealt with procedural rights through section 146. So under that, what it says is that a statement made by a young person will not be admissible as evidence against him or her unless it was voluntary. So that itself is an issue with a FASD youth, or even if it's not FASD, somebody who's delayed cognitively. When they're arrested by police, they don't necessarily understand that they have a right to silence. They don't understand that they can actually say no to the questions being asked to them. So they do not understand that whatever statements they make have to be voluntary. They feel that they have an obligation to make those statements at that time in response to the questions being asked. So this first step itself becomes an issue. So is the statement being provided, is it voluntary? In this case, if I remember correctly, this youth was actually interviewed late at night. He was only able to sleep for a few hours and then interviewed again first thing in the morning. So again, there is that pressure. So it's not a very convenient environment. It's not it's not where he can think clearly. So is the statement really voluntary then? And then the person who takes the statement should clearly explain to the young person in a language appropriate to his or her age and understanding. So that's taking us back to where I was saying, even when we provide a statement to the people who are admitted at the hospital around limitations of confidentiality, they have difficulty understanding that as well. So they need to simplify it as much as possible. And then there should be enough evidence, clear evidence, to suggest that the young person was given adequate opportunity to exercise those rights. So that is the right to silence, the right to counsel, and the right to have an adult being present when they are being interviewed. So in this case, the judge actually did not accept the videotaped interview as evidence. And the judge said that the person was not given adequate opportunity to exercise their rights. So what this case did was, it puts an onus on the police and the Crown to ensure that they can prove that the person who was being interviewed was able to understand all the rights and then exercise them, rather than just saying, you have a right to counsel, you have a right to stay silent, and these are the questions, and then the youth answers them. So it is quite significant from that point of view when we are dealing with fitness issues in youth. So from clinical point of view, we had a 14-year-old male of Aboriginal background. He was diagnosed with FASD. His full-scale IQ was 55. He was charged with assault on group home staff. He has absolutely no understanding of the court process. Sit down and talk to him. What are your charges? I don't know. Do you know why are you here in the hospital? No. Why were you in court? I don't know. Who's your lawyer? What's that? Do you know who are the people present in court? What? So this is somebody who's probably functioning at maybe 4 or 5 years of age. So he was found unfit, and he's unlikely to become fit. Now, the way the process works with fitness issues is, so if somebody has been found unfit in court, then the court would refer them or dispose them in a manner that they are under the jurisdiction of a regional mental health review board. So in Alberta, it's called the Alberta Mental Health Review Board. And then the mental health review board, in consultation with the forensic psychiatrist, would decide whether this person ends up staying in the hospital or somewhere in the community. And that is all based on risk assessments. So assessment of whether this person is a risk to self or others, what is the risk, and where can that risk be best managed. Now, the other option available to court is when it is determined that somebody is never going to become fit. So with this particular young man, we provided an opinion that he's unlikely to become fit ever. So his cognitive abilities are so limited that even if we try and teach him the process, he's probably never going to be able to understand that. If that was the case, then the court has another option which is called stay of proceedings. But that is contingent upon the risk. So if the risk is considered to be high, then they will continue to be under the mental health review board. However, if it is felt that their risk is not high, then the court can go ahead and deal with this individual with stay of proceedings, but that has to be agreed upon by the Crown Prosecutor. Now, the reason that it is important is when somebody is found unfit. Say, for example, this guy was found, as we know, this guy was found unfit for assault on group home staff. If he was sentenced, he could probably get maybe at the most 6 months sentence, whether it's custodial or community, based on the severity of the assaults. But when you are under the mental health review board, it almost becomes an indefinite sentence. Even though the board has the ability to discharge somebody, to give somebody an absolute discharge, but again that is contingent upon their risk. But this particular youth could be under the board for 2 years, 10 years, depending on how they progress, depending on if he engages in any other aggressive behaviors or not. So there have been arguments about restriction of liberty based on that, restriction of freedom by being under the board, rather than being the charges being dealt with and somebody being sentenced then. However, another argument to that is, yes, somebody is low functioning as a result of FASD, is impulsive, has a tendency to engage in aggressive behaviors. In some ways, by being under the board, the mental health services have an obligation to provide services and support to this individual till they continue to be under board. So the mental health services have to ensure that if he needs medication, that he's followed up regularly by a psychiatrist, he's seen by a nurse. If he's, for example, on injectable medication, he gets access to a therapist. A placement whenever he is discharged from the hospital has to be agreed up jointly by the carers as well as the mental health services. So there is a network of support that is provided for the person then. So there are benefits, but at the same time, yes, one could argue it results in restriction of freedom. So this is kind of what I talked about. Could be under the review board for a prolonged period of time. Sentence, if found fit, could be much shorter. So violation of charter right of freedom. And I said, as I said, it is justifiable if risk is considered to be high in some ways, because then the issue is about public protection. Another clinical case is we had a 17-year-old male who did not speak English, who came to Canada only about 2 or 3 years ago now, again charged with assault on group home staff, IQ of 58, has English as second language. He was found unfit. Now this is a young lad who's actually now 18, so he has support from PDD, he has AISH, and he continues to be under Alberta Mental Health Review Board. Now the good thing about being under the mental health review board was that most of these things for him, the age, the PDD, a placement, a psychiatrist, a therapist, were actually organized by us as forensic services. So he has all that support in the community now. A specialized placement was organized for him. He has a psychiatrist who's likely to follow him up every 2 or 3 months. And he gets all the required medication, support, everything. On the other hand, if you think about it from his point of view, he's not happy about this. He has to go back to the board every 3 months or 6 months or whenever the board says. He does even a minor thing in the group home where he is living, he could be sent back to the hospital. He doesn't want to deal with these things. One, because he has no clue what's going on. Two, because he's always worried, am I going back to the jail again or am I going back to the hospital again? I want to live at home. He calls the group home his home. I don't want to keep on going back there. And he try and explain it to him as to what's going on. I've personally done that about 50 to 100 times with him when he was an inpatient. Never managed to get through anywhere. So it's important to look at it from both points of view. From the point of public protection, from the point of being able to provide the right kind of services, but also from the point of view of the person who is the center of attention here. It is quite possible that if he was not involved with the mental health review board, he may not have had access to all this support and services that is being put in place now. So which is something to think about. So looking at another case, and in this is for an adult. In this case, I know it's a bit kind of overcrowded slide, but this was a decision from a judge where Dewhurst was somebody with FASD, and he was in court, and the judge opined that Dewhurst was unable to fully understand the nature or object of the proceedings as required by Section 2. I'm also satisfied that he's not fully able to understand the possible consequences of the proceedings. So going back to the same issue, do I know what's going on? Do I understand what's happening in court? It appears the only potential consequence he understands is jail. So what other consequences could be of being found guilty? It stays on your criminal record. Every time you apply for a job, your employer can ask for your criminal record. You may not get a job based on that. You may be restricted in where you can apply for jobs. So those are the kind of things that they cannot think about. So the judge further said that I'm satisfied that he may well be as much a result of his historical involvement with the system. So in the past he has been arrested, he has been to jail, so that's all he understands. And the judge also said that I'm also satisfied that based on the information that he's not in a position to adequately communicate with counsel in a way that would be meaningful in terms of his participation in his own defense. I'm sure saying this on camera, which is going to be available on the web for the rest of my life, probably is going to get me in trouble. But there have been occasions when I have called the defense lawyers on behalf of our patients and spoken to them and advised them that it is probably unlikely that your client is going to be able to tell you what to do. And I do not believe they have any understanding or ability to deal with this. Fortunately, there have been lawyers that I've dealt with who accept that and then act in the best interest of their clients rather than just working based on the instructions of their clients. So we need to understand that not every person with FASD, not every person with low cognitive abilities would be able to explain what they want. Sorry, it seems we have a question. So.
Yes, I have a question from Elle. And she asks, does a youth with or without cognitive challenges that is diagnosed with FASD, who's been admitted to a hospital and certified under the Mental Health Act. Does this person have the right to an adult who could help them should the RCMP want to question them, even if no charges have been laid while they're there?
Yes, every youth has a right to an adult if they are being questioned by police, irrespective of whether they are certified under the Mental Health Act or not, irrespective of where they are residing. So there are sometimes situations where some of the youth who are resident at the hospital with us do get interviewed by police, and we try and make sure that our social worker is always present with them, or a member of staff, nursing staff is present with them. So that right does not go away if they are under the Mental Health Act. It does not go away if they are in a hospital. It does not go away irrespective of where they are residing. So that right is always there. Sorry, there's another question, so we are going to wait for the mic.
So my question then is, with adults that are under guardianship orders and Guardianship Act, would they fall in any way under that as well, because they have lacked capacity, which is why there's a guardianship order? So is there some criteria or some protection for them to be questioned with somebody there to help them understand as well, if they have been deemed lacking capacity?
I must be very frank here. I don't usually deal with adults, but what I would understand from this is, if somebody has already been deemed to lack capacity, that automatically implies that if they are being questioned, or if they are somehow in conflict with the law, then they would have a right to have their guardian present when they are being questioned. And I'm pretty sure that there should be something in place for that, but I can't tell you exactly because I don't deal with that. We do have youth who stay with us beyond their 18th birthday as well, and if they are under guardianship, we have a legal obligation to involve the legal guardian in anything that happens. So that's why I believe that should be the case for older adults as well who are under guardianship. Maybe not in practice, but I think in theory I would be surprised if that is not the case. Yeah. Thank you. So coming back to Dewhurst, so there were also reports from psychologists and psychiatrists in this case suggesting that he had FASD. And in fact, in this case, the judge accepted it as a mental disorder, and Dewhurst was found unfit, and he was then referred, or he was then under the jurisdiction of the Regional Mental Health Review Board. So again, the courts have been, in some ways, inconsistent in the way they have dealt with some of these issues, and it is not necessarily because the courts have deliberately done that, but it is a reflection of lack of understanding on the part of judges, crown prosecutors, and defense lawyer. And in some ways, as health professionals, we have a huge responsibility to provide that education, to provide that support that is needed for the judicial system. There's another case that I would like to talk about, which is another youth, a 15-year-old who was in New Brunswick, and he was charged with assault with a weapon and making threats. He was functioning at the age of 7 or 8 years, and he had significant limitation in comprehension of concepts like guilt, like innocence. So he essentially had no understanding of what does pleading guilty mean, or what does pleading not guilty mean. So he was unable to participate in the trial process. Again, he was found unfit. So as you can see, we have talked about 3 or 4 cases. There are some who were found unfit, there were some who were found fit. So it varies. And if we look at the case where we were talking about limited cognitive versus analytical capacity. So if we use the principle of just limited cognitive capacity, some of these could have been found fit. So again, even within the judicial system, there is differences in how people with FASD are dealt with. So their language difficulties, their communication difficulties are not necessarily always seen as an impediment to their ability to understand the court process. Let's talk about not criminally responsible now. So not criminally responsible is another legal term under Criminal Code of Canada. And what it says is no person is criminally responsible for an act committed or an omission made while suffering from a mental disorder that rendered the person incapable of appreciating the nature and quality of the act or omission or of knowing that it was wrong. Now, most people straight away understand this concept if I talk about the Greyhound beheading in Manitoba. Most people have heard about it. It obviously hit national headlines. I wasn't personally involved in that case, but I understand he was found NCR and there were issues around mental disorder. So let's look at it from the break it into smaller issues, and then we'll talk about how NCR works. A mental disorder. So mental disorder is, again, I'm going to jump a few slides and then come back to it. It's a disease of the mind, which is a legal concept. So the judge defines what medical conditions are included within the term. So the included disorders based on that are any mental illness, a mental disorder, or abnormal condition which impairs the human mind and its functioning. So we know the common ones like schizophrenia, we know major mood disorders, so we know those things. Personality disorders. Now that raises a big question though, and we'll come back to them. DT, delirium tremens, which is caused by too much alcohol consumption over a long period of time, and mental retardation, so somebody who's functioning at a much lower age than what their chronological age is. So it also excludes transient disturbances of consciousness due to external factors like stresses, disappointments in life, voluntary intoxication. So someone has had too many drinks, gets into a fight after having drinks, and ends up stabbing somebody. Is that considered to be a defense? No, it isn't, because it was the choice of that individual to consume alcohol or drugs. So when we talk about deaths, DUIs, driving while under influence, and when that individual leads to accidental death of somebody, that's why they can still be charged. So being intoxicated is not a defense. Dissociation disorder. We dealt with quite an interesting case of dissociation, wherein this 16-year-old youth actually was at home getting ready, was living with his dad and stepmother. And stepmother called him, said, let's go to school, it's time to go. He comes down suddenly, and dad is gone, he was not home. So he takes out a knife and stabs her, and then slashes her neck. I think makes about an 8-inch long wound or something. She tries to run away from him, and he then pulls her back and then tries to stab her again. And then later claims that he had no memory of the incident at all. So this guy has no previous history of mental illness, has never had any other features of mental disorder since then. I guess anyone who kills somebody could claim to have a dissociative episode. Unfortunately, this guy was found not criminally responsible, and I still have no clue why. So, but these are things that by law should not fall under that category. So if this was a guy who had several dissociative episodes, who actually had a history of dissociative episodes, so sometimes when we talk about sleepwalking, even that can be a big question though. You don't necessarily perform complex activities when you're sleepwalking. So those are the things that have all been brought up as possible defense in case of serious charges. So those are the things we talk about when we are talking about not criminally responsible. So that's mental disorder. When we talk about appreciate nature and quality, so they should be able to understand what they're doing is wrong. And wrong is not a legal concept here. It's more of a moral concept. Yes, I know stabbing somebody is wrong, but I still have to stab this person, because if I do not stab this person, God is telling me that this guy is going to bring the world to an end. And God is also telling me it is my responsibility to save the world. And the only way I can save the world is by killing this guy. Even though I know it is wrong legally, but it is my religious and moral responsibility to do this. So what is important is to have a direct temporal relationship between the psychotic symptoms being experienced and the act being committed. So if I was hearing voices telling me I'm the king and I just decide to go and kill somebody, there is no relationship between my voices and my action. I know it is wrong to kill somebody, and I was trying to get the money from this guy. So that doesn't make me not criminally responsible. I still understand what I did was wrong. It was not a direct result of my psychosis. So that's where it is important, that to be able to appreciate the nature and quality of the act. Yes.
This is a question from Clinton. Can someone still be held criminally responsible if they suffer from post-traumatic stress disorder?
It's an interesting question. It depends on what Clinton is talking about, because PTSD itself is not something that can result in a finding of NCR. I would probably talk about a case from England actually, which resulted in a new law being formed in England based on battered women's syndrome. So this was an East Indian female who was in an abusive relationship for 5 years. So the husband was physically abusive towards her chronically over the previous 5 years. One day while the husband was sleeping, she actually decided to stab him several times and killed him. So she was assessed, and if I recollect correctly, this was quite a few years ago that I read about this one, she was found to suffer from PTSD. But the big question was, at the time when she committed the act, the husband was not physically abusing her at that time. If anything, he was sleeping. So the issue there was that with PTSD, when there has been chronic abuse or chronic exposure to trauma, one could still be suffering from the effects of that, which could then result in the act that she committed. And she was actually acquitted. She wasn't found NCR based on that. So the charges were dropped against her. Now, to be found NCR, it's a very broad category to define, to be able to just answer that whether somebody with PTSD can be found NCR or not is difficult to describe. But gosh, I'm trying to think of a scenario where I could say yes, if they had something around this, then they could be found NCR. Maybe if Clinton can give me some more details, I might be able to talk about it. So, as I said about nature and quality, and knowing that the act or omission was wrong. So knowing that stabbing somebody is wrong Not just wrong as in illegal, but knowing it is wrong to kill somebody. So if I'm thinking that I have to kill this person because God is telling me this is the only way to protect the world, then it is not wrong. Then it is the right thing to do. And that is the differentiation we need to make. So when we are assessing somebody for not criminal responsible or criminal responsibility, we talk about clinical interviews, we talk about the mental status of the accused. So the person who has been charged with the offense, what is their mental status? Are they someone who actually are psychotic? Are they hearing voices? Do they have delusions? What is their understanding of the circumstances? How are they able to describe it? What does the prosecution file say? What does the police report? So coming back to this 15, 16-year-old who stabbed his stepmother, the police reports actually said that he later had a rifle with him. And he went out. And that's it. It doesn't say that he was acting bizarre. It doesn't say that he was talking to himself. It doesn't say he stayed at the scene of the offense. So it gives you some idea. So this guy was probably trying to escape. He's not hearing any voices. He doesn't seem confused. He doesn't look lost. So was he really experiencing a mental illness at that time? Maybe not. So circumstances of the offense. Does it look like it was well planned? Does it look like it was out of the blue? What are the statements that have been provided by the witness and the victims? What are they saying? So is the victim in this case saying, oh, I tried to run away and I asked him what's going on. And he responded by saying, why don't you just die? So there was again no evidence of the person suffering from a mental illness there. So those kind of things. Previous psychiatric records. Are there records suggesting that this person had a mental illness? Have there been previous psychological, medical, or neurological tests? What has been the evidence of mental illness? As I mentioned earlier, whether there have been delusions, whether there have been hallucinations, whether this person has suffered from a mood disorder, whether there is history of treatment, whether there is evidence based on previous testing of impaired brain functioning, so becomes very relevant when we start talking about FASD. So if they've had an FASD assessment, if they have neuropsychiatric assessment, if there is evidence from birth records to say that there was prenatal exposure to alcohol. So whether they have had some psychological testing done to determine that they have a low IQ. And then when we talk about the actual offense itself, we talk about two aspects. We talk about actus reus and mens rea. So actus rea is the actual act, the act of stabbing somebody, while the mens rea is the mental state. So what were they thinking at the time of the act? So the law looks at intention and the act. So when I went to the pub, I knew that I already had information that Jack is going to be there. And I wasn't happy with Jack because he owed me $5,000. So when I went there, did I go with the intent that I'm just going to have a fight with him and make sure he gives me the money? Or I went with the intent that I'm going to kill him if he doesn't give me the money today? How do you determine that intent? By actions. Did I go in there with a knife? Did I go there with a gun? Did I tell somebody I was going to do that? When I went there, did it start as a verbal argument? Or did I just straight away take out my knife? So it's difficult to read the mind, but it's about trying to understand the state of the mind based on the circumstances. And it becomes relevant when we look at this case. So this was a 15-year-old guy who actually killed his stepfather without any provocation. So he gets up in the morning, stepfather was in the bathroom, he was just shaving, and the guy walks in, stabs him 2 or 3 times from the back without anything at all. And then he sits there in the house with his mom when mom finds out, calls 911, mom is panicking, so he speaks to the person on the other end and tells them, look, my dad is dying and I stabbed him and he needs help. What does it tell you? You already start thinking there's something wrong here. If he was planning to kill his dad, he would make arrangements to run away. He won't sit there and talk to them and tell them, I did this. So this guy was having delusions. He had these firm beliefs that this stepfather was an imposter who was there to kill him. And he had to protect himself. So this guy was found not criminally responsible. Another example, a 20-year-old male with history of mood disorder, but no history of recent contact with mental health services, has been fairly stable, absolutely no issue, but smokes weed on a daily basis, some days a joint, some days more than a joint. Ends up killing his brother, and then does everything to hide all the evidence. So tries to hide the gun, runs away from there, is found somewhere else, and then claims that he does not remember anything and that he has been hearing voices telling him that the CIA and the FBI are keeping an eye on him and his brother is part of that, and blah. And none of that was evident on during the days preceding to the offense itself. So it's important that we look at those things when we're talking about criminal responsibility. So I'm not sure if that might help Clinton to understand some of that stuff, but I'll probably be able to understand his question better if I have more details around that. This is another guy, 17-year-old, diagnosed with FASD, under the care of Child and Family Services, permanent guardianship order, low IQ, 58. He was living in a group home. While there, he went out with three other youth, and they started kind of playing with each other, wherein these two youth and our guy started doing sexually inappropriate things with the victim. So the two other guys who were higher functioning than our guy were almost egging him to do this. At some stage, the victim said that he does not want this to be carried on. Our guy, who has a low IQ of 58, who has FASD, does not understand that he's now supposed to stop. And he's subsequently charged with sexual assault. He has no understanding of what a consent is, what does a consensual relationship mean, when is it that he's supposed to stop, when is it that it is a no is a no. But even before he reached that stage, he didn't even have any understanding of the court process. So here we dealt with the fitness issue, and we were actually able to make him understand the court process. So he was found fit. But then we started talking about the intent. So that's mens rea. Did he have the ability to form an intent to do what he did? Or was he being influenced by the peers who were there? And that's why he ended up doing what he did. And that's not unusual for people with FASD. Because they are usually isolated, they usually don't have friends or family, they want to be part of group, they get easily attracted towards antisocial peers who use them, who sometimes threaten them, sometimes tell them if you do this you can hang out with us, and that's where it becomes a big issue. So the duress issue, were they forced to do it? Was it really a voluntary act? Becomes an issue. But it's not that simple, and I'll come back to that. In that, when the concept of not criminally responsible is around a major mental illness, which is short-lived and is generally treatable. FASD does not necessarily fall under that category. So, because there are people who have normal IQs. So the biggest issue there is because they are impulsive, they committed the act. And impulsivity cannot be used as a defense. Impulsivity does not fall under not criminally responsible. So another one, 18-year-old with possible diagnosis of FASD. His full-scale IQ is 90, which is almost in the average range. This guy is charged. This guy has a long history of aggressive behaviors. Is charged with assault against mother. Does he have the appreciation of the act? He knows what he's doing is wrong. He knows hitting his mom is wrong. He knows that it is morally wrong as well as legally wrong. This guy was interestingly found not criminally responsible. So, which was, the reason I say interesting was because, yes, he's impulsive. Yes, he has got FASD, but he has a clear understanding of both his actions as well as the impact of his actions on the victim. So does that necessarily fulfill the criteria for being not criminally responsible? Questionable. But that again is a reflection of unclarity within the criminal justice system as well. And that is a reflection of unclarity within mental health services. Because we as mental health professionals as well provide different recommendations while we are making same kind of conclusions as far as diagnosis and deficits are concerned. Sorry, we are waiting for a question.
So just wondering, since FASD tends to be pervasive, lifetime, would it be fair then to compare it to a later acquired brain injury, and what kind of implications would that have? So if that's a comparable way to look at it, what kind of, because sometimes brain injuries can cause aggressive behavior things and impulsiveness again because of damage to, frontal lobe or something.
Yeah.
So if that's the case, is there any basis for using that as a defense, I guess?
It definitely is, and it's an interesting question because the important thing to understand is with acquired brain injury, there is clearly a recognizable event. So it could be a result of a motor vehicle accident or a head injury from an assault or something. It results in clearly not necessarily always, it results in sometimes demonstrable or visible brain damage on things like MRI, and then it could result in a clear association, a temporal relationship between the acquired injury and the onset of behaviors. So to give you an example, we had a 14-year-old lad who had a head injury when he was 12. He had some behavioral difficulties, but nothing significant prior to that. And after the motor vehicle accident, he started having seizures as well. So once he started having seizures, his behavioral difficulties increased and his memory started to go downhill. Subsequently, he was charged with a couple of assaults. Now, the interesting aspect of this particular youth is that he understands the concept of the court. He knows everything what happens in the court. But because of his memory difficulties, he cannot actually retain that information. So when he goes to the court, he just doesn't remember what is supposed to happen there. So this particular youth is found unfit. But it is easier for somebody like him to be found unfit because there is a clear precipitating event. There is a clear temporal relationship between the event, which is in this case a motor vehicle accident, which is then associated with increased behavioral difficulties. So he's charged with an assault on group home staff and associated memory difficulties. While somebody with FASD is essentially born with that, may not have a demonstrable brain injury and usually gets identified as a difficult child even when they are growing, and then as a difficult teenager or an adult without any specific precipitating events.
It doesn't sound very fair, though, does it?
It doesn't. It doesn't, and I agree with you. So, and that's where the issues come in. That's where the courts are confused as well. That's why some of these people are found unfit, some of them are found fit, some of them are found not criminally responsible, some of them are less so. But what is important to understand is that till about a decade ago, FASD was not even raised as an issue in courts. And over the last few years, it is being increasingly recognized as a significant issue in the criminal justice system. And I will refer to some of that as well, because it deals with your concern about it not being fair. So, and that's something to do with Gladio reports, Gladio court cases, and I'll talk about that. But that's where issues are. And I must say, I have personally been involved in cases where I've thought, do I go down the road of saying so-and-so can be helped by treatment, or do I go down the road by saying, no, this person cannot be helped by treatment? But that is influenced by a number of factors. So those factors are, say for example, younger the person, more likely are we, or am I to say that this person would benefit from treatment? Because in some ways, whether it's fair, whether it's unfair, whether it's the right thing or not, but the younger they are, there is better control from the system over them, or you would hope so. There are more services available. The services are, and the system is still legally mandated to provide services to these people. The second factor that influences the decision is the severity of the offense. So if this offense is of a very serious nature, then generally the decision is more towards consequences rather than towards treatment. The third factor is what is available outside there. So to talk about another one of the youth that we dealt with, 17-year-old was charged with several serious violent offenses, FASD, and we actually agreed to go down the road of treatment with this youth. And so he was admitted to the hospital. He was with us for about 18 months. He did exceptionally well. He was one of the most polite, pleasant youth we have had. He was the role model on the unit. He's discharged. In a week's time, he's back in prison. Because the system does provide support, but the way the system works is most of our services are available from 8 o'clock in the morning till about 6 or 7 in the evening. When do you go out and get drunk? When do you go out and use drugs? When do you meet your peer group? When do you get into trouble? It is actually after that time. And that is when he got into trouble, got drunk, and was back in prison. So even if this person was somebody who had another year or 2 years of community sentence, do I need to stop? No. So even if this person had another 2 or 3 years of community sentence, and there was strict supervision available in the community with 24/7 supervision and support, what will happen after 3 years? We are back to the same place. We are back to square one. And that's where the biggest problem is. Alberta is way ahead from the rest of the provinces in the country when it comes to assessment, when it comes to identifying FASD. But I don't think we are talking about interventions. We're not talking about what happens once they have been diagnosed with FASD. What happens if a 17-year-old youth with FASD has had 50 charges over the last 2 years, and we want to rehabilitate this youth? What are the services available out there? Nothing. even if they are referred for treatment while they are during the period of their sentence, you can provide that treatment for 2 years, 3 years, 4 years. What happens after that? We all know from the research, we have all learned very well that they need structure. We talk about the concept of an external brain or a second brain. But then, when we talk about consequences, when we talk about treatment, all we are doing is we are either providing that supervision, we are providing that structure, we are providing that treatment for 2 years, 3 years, and then expect them to live independently without any trouble. That's not going to happen. We have already established they don't learn from mistakes. We have already established they don't do well without structure. So potentially, in some ways, what we are talking about is if a 16-year-old or a 14-year-old comes in contact with the criminal justice system or mental health services, has been diagnosed with FASD, we are potentially talking about services which last throughout their lifetime. We are not talking about 2 years of service. We are not talking about 5 years of service. We are not talking about 10 years of service. We are talking about for the rest of their life. So it doesn't really help if somebody gets a 3-year sentence with 3 years treatment on that. It doesn't work. It doesn't do anything. If anything, it works as a waste of time and money. Because you may have kept him safe for those 3 years. You may have protected the society for 3 years. But unless that support continues for the rest of the life, it doesn't do anything. So yes, it is unfair, what you are saying. But then the problem is, till we have the resources, it's always going to be a question of, is this really going to help? And that's the problem. Sorry, looks like I may not be able to go through all my slides. So I'm going to skip 1 or 2 cases because I want to leave 10 minutes at the end if there are any questions. So we've already talked about this, as in the meaning of wrong is not just legally wrong. It's not simply legally wrong. It's morally wrong as well. And unless we are able to establish that clear relationship or clear evidence that the person who committed the act was unable to understand that it was morally wrong as well, then they cannot be found not criminally responsible. So it focuses on a general capacity to know right from wrong. But at the same time, that right from wrong should be specifically related to the circumstances. So going back to either the guy with FASD who sexually assaulted a youth, does he understand it's right? Or does he understand his actions were wrong? That's where the problem comes in. He probably did not understand that they were wrong because at some stage the victim actually started saying no. And then it becomes wrong. He had difficulty differentiating that yes from no, differentiating when the playful act actually became forceful. So that's when it became a problem. Or for example, when the other 16-year-old stabbed his stepdad. He knew it was legally wrong probably, but he did not know it was wrong. He did not believe it was wrong because he had to protect himself from that imposter. So it's about understanding that difference at the time of the commission of the act. It should be specific to those circumstances. And he did not try to hide the evidence. He sat there, he waited for the ambulance, he waited for the police to come in. It just didn't go anywhere at all. So that's what is important, the capacity to think rationally. So here the capacity to think rationally is gone because I'm delusional, because I think this is an imposter. And then based on that making a decision whether it is right or wrong. So that's where when we talk about the youth with FASD, he could not think rationally because he doesn't understand when is it that it was a game, and when is it that it stopped being a game. So now the victim is actually getting troubled by what is being done. Now it has become a forceful act. Now it's not a game anymore. So that's where it's important to differentiate those two things. And we have talked about some of these things, but just to go through them quickly. So evidence of knowledge of wrongfulness is try and avoid detection, wearing gloves, waiting under the cover of darkness, taking the victim to an isolated place, wearing a mask, concealing the weapon, falsifying the documents, providing a false name to the police when arrested, threatening to kill witnesses, giving a false alibi. So all those things are clear. They're commonsensical things in some ways. So if somebody knows what they're doing is wrong, they will try and do all these things at the same time as well. They try and get rid of the fingerprints, they try and wash off the bloods, they will try and get rid of the clothes that might have been involved in that, shoes, disposing of the murder victim, anything that can connect them to the evidence, they will try and get rid of it. Again, we have to focus on what was the statement of the victim, of the accused, of the person who committed the offense. So this guy with FASD who committed the sexual assault, when we tried to talk to him, he had no clue what we were talking about. He had no idea what was going on. I was playing with him, we all went to play, and that's about it. So he didn't understand that the sexual act that he continued to carry on with was actually an offense. It was something that was unacceptable both legally and morally. So he did not have that understanding. Expression of remorse or guilt can go both ways. With FASD, they may have difficulty expressing remorse or guilt sometimes, while somebody with a personality disorder may express remorse or guilt despite the fact that they do not actually feel it. Yeah, I feel bad, that happened to them. So there's no emotion associated with it. Delusions, hallucinations, as we have already talked about. This one was interesting in that this guy was charged, he's an adult, he was charged with break and enter, threats and failure to comply. He had a long history of criminal behaviors. On this specific day, when he committed the act, he also consumed alcohol. So he was quite intoxicated. Now we have already talked about voluntary intoxication is not a defense in itself. But in this case, the issue was he also had FASD. And the judge actually took that into account and essentially said because he had FASD, he had difficulty making the choice whether to drink or not and when to stop. So in some ways it deals with the issue you were raising, whether it's unfair or fair. Here the judge has almost gone to the other extreme, saying it also affected his ability to control his level of alcohol consumption or drug abuse, which then resulted in the crimes that he committed. So he was found not criminally responsible. Now the other interesting thing, if you notice, quite a few of the cases that I've talked about are from Yukon. And it seems that if we look at the proportionality of cases related to FASD, it is actually, one, it is going up. Two, most of those are being raised as an issue in Yukon and Northwestern Territory. So there the courts are recognizing FASD much more in comparison to other provinces when we talk about the ratio, when we talk about the proportionality. So quite a few of these cases come from these territories. Now this was another one where this guy was again with FASD, was charged with breaches and property offenses. In this case, the judge said that this person understood the nature and quality of the acts, and NCR was not available. So what is interesting is, if you look back, they are both FASD. They both probably understand the nature of their acts, that they are morally wrong. But in exactly the same kind of circumstances, one is found NCR and the other one is not. And that's what I was talking about earlier, that it depends on the circumstances, it depends on the severity of the offense, it depends on the resources, it depends on what is out there. What is the possible risk to the public? So if somebody is charged with a murder, and they have FASD, so their potential risk to the public is much higher than somebody who is probably charged with breaches or property offenses. So those are the kind of things which end up affecting the recommendations as well as the final disposition by the court. So it is not necessarily just being based on a diagnosis of FASD. It is not necessarily just being based on the deficits associated with FASD. So there are a number of factors that are considered. However, the judge in this case said that the disabilities related to the FASD should be considered during sentencing. So I don't know what was considered in this case, but it could be because he has limited cognitive deficits. So whether he should go to a custodial setting or whether he gets a community sentence. What kind of conditions are imposed on him? What kind of cultural supports are available for him? So those are the kind of things that could be considered during sentencing. We'll skip this slide because we have talked about this. So the issue is, as I said earlier, that the concept of not criminally responsible as a result of mental disorder is based on severe treatable mental illness. And impulsivity associated with FASD does not necessarily fall in that category. It's difficult to determine what is impulsivity. It's easy to fake. Doctor, I just couldn't control myself. How do I know whether that was an act of impulsivity or not? And even then, one can still assess the ability of the accused to understand right from wrong. But to assess whether somebody committed an impulsive act or not is much more difficult. And that's where the issue comes in. So this is talking about what you were earlier saying about fair and unfair within the judicial system. So there was a case in 1999, R versus Gladu, where the judge actually looked at the available sanctions, specifically keeping in mind the cultural background. And in this case, Gladu was an Aboriginal female who had been in court and had actually requested that her sentencing be considered in view of her background of her being FASD, as well as having some relationship, and I can't remember what it exactly was, with residential school system. So the judge then came up with this, suggesting that all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders, with particular attention to the circumstances of Aboriginal offenders. So that came to be known as Gladu case, and since then there have been courts that are specifically designated Gladu courts, which now exist in Toronto, and there have been Gladu caseworkers that have been appointed specially to provide reports for offenders who come from Aboriginal background, to look at what are the other options available rather than just sending them to custody, in order to provide them with cultural support, with support in the community. So these courts have professionals in them who are expected to have special understanding and expertise in the range of programs and services that are available for Native people or First Nation people. Alberta now has a Gladu worker, and I have seen reports done by Gladu caseworkers for some FASD kids that we deal with. So there was a case in Alberta actually in 2005 of a 14-year-old youth who was diagnosed with FASD, was charged with first-degree murder of his worker. He beat her up with a tree branch and then sexually assaulted her. He was given a life sentence. The argument of the judge was that he should get a same sentence due to the seriousness of the offense, despite the fact that the judge did consider other factors, but because of the seriousness of the offense, judge decided to go along with a sentence that might possibly be given to a non-Aboriginal person. Another case here, a 20-year-old Aboriginal male with FASD pled guilty to impaired driving and 4 counts of robbery. Gladue report was considered in this case. Community was given opportunity to set conditions. So we are talking about local community for this young lad. However, the court did say that sentencing under principles of restorative justice may not always be possible. Now, to give you an example of that might be, say, if this is a youth, and I'm not talking about this specific youth, I'm just using him as an example. If this was a youth who has a long history of alcohol abuse and intoxication resulting in serious offending behaviors repeatedly over a period of time, even if the community is able to provide some support, say, oh, we'll provide him with an addictions counselor, or we will provide him with an elder, or he could be part of Sundance. Some of those things may have been used in the past, but with little effect on the person, on the individual. So in that case, the court has to consider whether that kind of restorative justice, whether those kind of conditions are actually going to reduce this person's risk or not. And in that case, the court may still decide to go down the route of deterrence rather than using restorative justice there. Another one, this is from BC as well, robbery while intoxicated. He had history of physical and sexual abuse, running away from home, again diagnosed with partial FAS. And the judge in this case ruled that jail would not necessarily act as a deterrent to him, because people with FASD do not learn from consequences, they do not learn from mistakes. So, and the other thing the judge said was that he will continue to be an ongoing danger without treatment and help. So he was given a conditional sentence in community with supervision and cultural and mental health supports. Now again, if you look at this one and this one, oh sorry, I went the wrong way. There's not much of a difference between the two, is there? They're both the same. FASD, alcohol-related issues, unlikely to learn from consequences, but in one case, he gets a custodial sentence, in another one, he gets a community sentence. And that's been an issue, that even with similar kind of presentation, there have been problems as far as providing support is concerned, as far as accessing resources is concerned, as far as ensuring that the risk is managed properly is concerned. So the fact is that there is ongoing lack of clarity in criminal justice system around FASD. And that's not because of lack of trying, that's not because of necessarily lack of motivation, but it is also because that is how the mental health services have guided the criminal justice system in some ways. Even within mental health services, we are not clear as to what is a good way of dealing with these people. And in some ways, I would like to say that is because of lack of resources. So even if we want to help somebody, we can provide that treatment or support for 2 years, 3 years. So a 15-year-old gets that support for till 18th birthday. What happens after that? They're back in the community without any support, without any supervision, without any structure. So we are leaving them. And the unfortunate thing is, if they are in a very structured hospital environment or a group home environment, not that most group homes are structured, but if they are fortunate enough to be in a structured group home environment, suddenly they go from 10 to 0. So in that they have got all that intensive support, treatment, everything while they're in a structured setting, and then they're in the community left without anything at all. And it does not fall under typical definition of mental disorder, as we discussed. It's not something that is treatable. It doesn't go away. And our concept has always been mental disorder is something you provide medication, you provide therapy, you provide support, it goes away, it can come back, but there are periods of stability. So there are periods when the person can function better than what they usually do. Well, that is not the case with FASD. So you cannot withdraw services at any stage. Those services need to be there all the time, throughout the life of the individual. They're not treatable. They're not transient conditions. There is clearly a need of better cooperation, better working relationship between mental health services and criminal justice system, a need for greater education, greater training, a need for better resources. It doesn't help spending $50,000, $100,000 on assessments if we are not going to follow up with the recommendations for those assessments. It's a waste of time. It's a waste of money. If it doesn't lead to some change, if the outcome doesn't change, then why bother to do them? It's all good to have those needs identified, but then what? Nothing. And that's what the issue is. And in some cases, they get shorter sentences. In some cases, they get longer sentences with exactly the same kind of presentation. And it is because of these number of factors that we have talked about. And it's not there is no easy way out. So I guess that's where I will finish. I don't know if you have any more questions.
One more question from
May an adult under the Mental Health Review Board in a community placement like a group home be confined to that home if necessary?
It depends on the disposition of the board. The board can actually make a condition that that person has to live in a specific place. Having said that, I haven't come across a disposition where a board has specified that that person is supposed to live in the community in a group home and not allowed to go out at all. Usually those kind of restrictions are limited to secure hospital settings rather than to a community group home. And to be very frank, I'll be very surprised if that was the case, because what that is also telling me is that this individual's risk is considered to be high. And if that is the case, then it is likely that the board may make a disposition for this individual to go back to the secure hospital setting rather than staying in the group home. The individual can actually have an argument that this would be against his charter of right to freedom, and I think it's seventh right, if I'm not wrong, and it has been challenged in court in the past. Even just being under the Mental Health Review Board has been challenged, leave aside being restricted to a group home place. Okay, thank you. Oh, yes, sorry. My email address is my first name dot last name at albertahealthservices.ca. So it's Vinesh, Vinesh, dot Gupta, Gupta, at albertahealthservices.ca. Thank you.
Thanks very much for a great presentation. I found your examples really informative, and I thought they did a great job of illustrating this really complex topic. Just a couple more business items. Your evaluations will be emailed to you within the next 2 business days. If you're attending in person, make sure you've signed in on our attendance sheet. Your feedback is really important to the continued success of this FASD learning series, so please do complete your evaluations. Our next presentation will be on April 16th, when Vanessa Buckskin, who's the FASD Clinic Coordinator for Siksika Health Services, will discuss the use of family-centered PCAP program model in a First Nations community. Thank you.